Hello, and welcome to today's webinar. What does the EU AI Act mean for executive search and leadership consultancy firms? We invite you to submit any questions into the Q&A panel on your screen. Please note this webinar is being recorded. It is now my pleasure to turn the session over to Clare Mahon. Please go ahead.
Good morning, good afternoon, and good evening, everybody. Welcome to today's exclusive webinar for AESC members, where we will discuss what the EU AI Act means for executive search and leadership consultancy. For those of you who don't know me, I'm Clare Mahon, the Managing Director for EMEA. I'm delighted to announce that AESC has an exclusive partnership with Fieldfisher, a leading international law firm. Joining me today is Felicity Fisher, partner, and Richard Lawne, senior associate. So before we start, can I ask actually both of you to give a quick introduction of who you are? So let me hand over to you, Felicity.
Thank you very much, Claire. Yes, hello, good evening, everyone. Good morning, wherever you're based. So I'm Felicity. Lots of people call me Flick. I'm a partner based out here in the Silicon Valley office of Fieldfisher. So we are, as Claire mentioned, an international firm. So we have offices all over Europe, and we have Fieldfisher China. And I'm one of the lucky partners that gets to help sort of manage and run our Silicon Valley office. So we have 16 lawyers based out here, all of whom are here to advise our US client base on European issues. And I myself am a privacy and digital regulatory specialist. So I help our clients kind of navigate the privacy regime in Europe, as well as all of the sort of adjacent digital regulation that we have, and that now includes the AI Act.
Okay, thank you, Felicity. And Richard, if you'd like to introduce yourself.
Thanks, Claire. My name is Richard Lawne. I'm a senior associate at Fieldfisher, and I work alongside Felicity. I'm also based in the Bay Area in Silicon Valley, but from our accents, you might be able to tell that we don't sound American. Both Flick and I are from the UK originally, and we are both advising clients on privacy and digital regulation, and increasingly around compliance with the EU's AI Act. I myself have a particular interest in AI, and I've recently completed a master's at Cambridge University on AI ethics. So it's certainly an area that I find very interesting in, and I'm excited to partner with AESC on navigating AI Act compliance.
Thank you so much. And for those of you who are listening, I encourage you to write your questions that you may have in the Q&A box. We'll try to address as many of them as possible in today's webinar, but just so you know, this is the first of a few webinars we will have in relation to the EU AI Act as we go through the next 18 months. If I can go back to you, Felicity, can you briefly introduce a little bit Fieldfisher and your role in advising on AI regulation?
Yeah, sure. So as I mentioned, Fieldfisher is headquartered in London, but we have offices all over Europe. We've recently just opened an office in Poland as well. And then I'm one of the partners that sort of helped grow our Silicon Valley offering. So we have a fantastic team of specialists, a deep bench of specialists out here in the US, all of whom are kind of tasked with helping our US clients with European issues. So we don't do any US law out here, despite being based in the Silicon Valley, but we're here to make sure that we can kill the time zone for our US clients. And because of where we sit, we're based out here in the Silicon Valley, which is the heart of where loads of the AI innovation is obviously happening. We're in a really unique position of being able to lift the lid and sort of get to have a peek at what's sort of going on in terms of the new technologies coming down the line. And a huge part of our practice at the moment is helping our clients build, integrate, deploy AI technologies, and therefore, as a result, kind of navigate the growing set of legislation that they need to think about. So we've had the privacy laws for a while that they've had to navigate, and now we're having to think about the AI Act. So we get to really kind of see what sort of innovation is coming down the line and help steer those companies to kind of design and develop and integrate those tools in a compliant way. So to do that, we have to be very practical lawyers. We have to get stuck in and understand the technology, and then find sort of pragmatic, practical ways to help people navigate what's an increasingly difficult and complex array of different legislation legislation to navigate. So it's a really interesting space for us to sit in, and we're really excited to be kind of partnering with the AESC to kind of share some of our insights. A number of our clients are in the executive search space, so we're really looking forward to sort of getting stuck in and sharing the knowledge that we have, and also learning from the members too.
That's great. And thank you. I mean, you know, AESC is a global organization with members in 88 countries worldwide. And as we embark on this partnership, AESC's objective is to provide our members with guidance on how to operate within the framework of the EU AI. And Felicity, from your side, what would you like to achieve through this collaboration between AESC and Fieldfisher?
Yeah, well, our goal is very much to make sure that we're giving your members really useful, practical guidance that they can use to help to understand the extent of their compliance obligations and start to put in place the right size kind of compliance program to meet some of those requirements. There's a huge amount of law at the moment out there, and sort of helping people digest that in a practical way and come up with, you know, a program of compliance that works for them is something that we hope to achieve out of this. So we've, you know, worked to put together a really interesting and hopefully very useful scope of deliverables for members that we're going to start to be pushing out. Starting off with, I think, the first set of documents which we're working on, which is really to break down the key sort of terms under the AI Act in a way that makes sense for executive search. And then we're going to do a sort of really useful and hopefully practical explainer on how the AI Act applies to executive search. It's going to reflect lots of the things that we're going to discuss today in the webinar. But there'll also be really a lot of other interesting deliverables that we're working to push to members. There'll be some great flow charts, some decision trees. We're going to help look into certain scenarios and provide a practical overview of how the AI Act is going to work in certain scenarios which are highly relevant to executive search. And we're also going to provide and develop some tools to practically help members navigate compliance, some policy documents and other things. So hopefully you're going to start to see some really useful collateral come from our collaboration. We're also going to do more webinars. This is almost a sort of overview webinar of how the AI Act applies, and then we hope to go and dig in and do some more kind of practical webinars which will look into other specific aspects of the Act that members need to be mindful of. So it's you know, we're really excited for the partnership and the chance to get to meet members and share our knowledge and you know, build some really hopefully useful toolkits for everyone.
Now, that's great. I mean, we are delighted here at AESC, and I know that you know, we AESC, of course, we work very closely with the Global Legal Affairs Council, or the Legal Affairs Committee that we have, which is comprised of our members. And we say not every member has a council, but those that have are participants. So we worked very closely with them in relation to ensuring that the global data privacy regulations, the guidance that we gave to our members, and we'll be working very closely with them as well as we evolve through the guidance that we're going to give to our members in relation to the EU AI Act. And maybe I know you gave a brief overview there of the documents that we have, and we'll probably touch back on them later at some point. But I don't know, Richard, maybe would you like to help us sort of understand a little bit the AI Act? I mean, not everyone is familiar with the AI Act, and what, you know, so what is the EU AI Act in a nutshell, and what is its primary objectives?
Yeah, thanks, Claire. So the AI Act in the EU is really the world's first attempt to introduce a comprehensive legal framework focused on artificial intelligence. There are a number of laws out there that may indirectly regulate AI, and there are also some more targeted legislation and regulations focused on AI. But the EU's introduced this blockbuster landmark piece of law that's really trying a more comprehensive approach. And its main goals are to ensure that AI is developed and used safely, transparently, and in a way that respects fundamental rights and values, particularly in high impact and sensitive areas. In terms of what it regulates, the AI Act focuses on two main types of AI. The first are AI systems. These are tools that operate with some degree of autonomy and generate outputs. If we think about tools that generate predictions, decisions, analysis, or content based on the inputs they receive. So AI systems include a lot of the AI-powered tools and software that we might be using today already, like chatbots and software tools used for CV screening, etc. And that really includes a very wide range of AI tools. The second category of AI that the legislation regulates is called general purpose AI models. This is a little bit different. So these are large flexible models like Gemini or GPT that can be used to perform a wide range of different tasks and used across different industries. And these large models are often embedded within AI systems and used to power AI technology. But the AI Act sets specific rules for their development and use, especially when those models pose a higher risk or so-called systemic risk. In terms of who the AI Act regulates, it applies effectively to anyone involved in the development, distribution, or use of AI within the EU. So that includes both providers, that's organizations that develop AI technologies, and it also includes deployers. Those are organizations that use AI tools as part of their business operations and for their own internal purposes.
Thank you very much for that overview for us. And maybe you could just say that what should executive search and leadership consulting firms care about, when it comes to the AI Act?
Yeah, that's a great question. I mean, we're told a lot that AI has the potential to transform how we work. And already we're starting to see AI helping consulting and search firms streamline CV screening, analyzing candidates, assessing leadership potential. And we're also we're seeing new AI tools being used for more day-to-day tasks as well, like search, drafting and research, and also knowledge management. So these tools are out there, they're coming, and they are being increasingly useful. They promise to help deliver improvements in speed, efficiency, and also to give us greater insights. But we know that there are risks as well, and the use of these technologies raise some important questions. For example, can we explain how a candidate was ranked or rejected by an AI tool? Are the algorithms making fair and unbiased decisions? And also, do the candidates themselves know when AI is involved in their selection and assessment? And really, these are the kinds of questions that the AI Act is designed to address. So as AI becomes more deeply embedded in the systems that we use and the technologies that we use, understanding this regulation is really essential. Also, and as we'll see, a lot of the tools that are used in executive search are likely to be heavily regulated under the AI Act. And that triggers a range of different compliance obligations. So it's going to be important from a legal compliance standpoint. But I'd say it's not just about a legal checkbox or compliance exercise. So ensuring that the tools that you're using are going to comply with the AI Act is a legal responsibility, but it's also about ensuring you're protecting your firm's reputation and maintaining trust both with clients and candidates as well.
And thank you, Richard. That's really important for us as a profession that we are protecting our reputation as well as making sure that we're protecting our clients and our candidates. Richard, how does the AI Act affect AESC members if they're not based in the EU?
Yeah, this is a really important question, particularly for global firms. So the AI Act primarily applies to organizations that are established within the EU. So if your firm has an office or presence within one of those 27 EU member states and you're using AI, then you'll be caught within scope. And just to clarify there, the UK is no longer part of the EU, so no longer counts within those 27 member states. However, the AI Act also has what's called extraterritorial reach, and that effectively means it doesn't just apply to companies and firms within the EU, it also applies to firms outside the EU if the outputs of the AI system, so those predictions, decisions, the content I was referring to before, if it is used on EU individuals. So in practical terms, what that means is if you're using AI to source, assess, or shortlist candidates who are located within the EU, then the AI Act will be triggered. So let's say your firm is actually based in New York or Singapore, but you're using an AI tool to help fill a C-suite role in Paris or Berlin. If that tool is influencing the hiring decision, then that potentially triggers the AI Act and the need to comply. And in that scenario, you would be considered a deployer of the tool, a user of the tool, and you'll need to comply with the relevant obligations. So Claire, in short, if your AI touches EU talent and employees, then the AI Act touches you and it's going to be relevant.
Okay, and thank you, Richard, for that clarification. I think we're probably going to dig much deeper into that in further webinars, so we can understand really how to navigate it, how to use it for those firms that are outside of the EU, and of course those that are within. But maybe I'll just ask you a quick question, because you referred to the UK, who is no longer part of the EU and the 27 states. So what is sort of the current alignment? Where does the UK sit?
So the UK hasn't yet introduced AI regulation. It's in the works. So there is a draft bill that's going through the legislative process. But as you can imagine, Claire, it's highly debated, and there are some controversial aspects to it. So we're yet to see exactly how the UK is going to regulate AI. But what is clear is that they've said they're going to be a little bit more pragmatic and business friendly in their approach, and they don't intend to introduce as robust regulation as the EU. So we're not expecting the UK to introduce something like the AI Act. It might be a little bit more limited in scope and more targeted, and we'll have to wait and see. But at this stage, I think most eyes are focused on the EU, both because of its size, but also because the regulations are a little bit more strict.
Thank you, and thank you very much. I know you are going to keep us abreast as things move along in the next few months with that. And Flick, maybe you can share with us what are sort of the key timelines and milestones that we should be aware of as the Act is moving into implication.
Sure. So the Act officially entered into force on the 20th of June last year, but its provisions are being rolled out on a kind of phased basis, the thought being that that will give organisations some time to prepare. And in the background, it's worth also remembering that all of the sort of infrastructure required to then enforce the Act is also being set up. We're also waiting on a huge body of guidance that's supposed to be published to help people understand and navigate how to comply. So there's quite a lot of infrastructure in terms of guidance and enforcement mechanisms that's still got to be set up. But the first set of rules, which is covering prohibited AI practices and AI literacy requirements, we'll talk a little bit more about those in a second. They actually came into effect in February this year. So the Act kind of sets out a sort of set of use cases, sort of AI technology use cases, which are deemed to present an unacceptable risk and an outright banned in the EU. So that ban for those particular use cases, for those prohibited AI systems, came into effect in February. The core of the obligations under the Act will apply to regulate what's called high-risk AI systems, which are subject to the most stringent requirements under the Act. And there are also a set of transparency requirements which will apply to a number of AI systems, irrespective of their risk categorization. And those are all going to start to be enforceable on the 2nd of August, 2026, so this year. And this phase will include, as I say, key rules affecting how AI is used in recruitment, candidate assessment, and employment-related decision-making. So key date there. We've also got, as Richard mentioned, there's a lot of separate provisions which apply to regulate general purpose AI models. So think of your Gen AI models that the likes of OpenAI and others have been pushing into the market. There's separate timelines for those provisions. The providers, so OpenAI and others of those models, will have to meet certain governance obligations starting from August this year. And then there's further details and technical guidance to be issued by the AI office to kind of beef up and better understand the scope of those obligations too. So really for your high-risk AI systems, which is where we think a number of the executive search focused AI tools are going to fall, we're talking about August next year.
Thank you, Felicity. I know that you're going to keep us on track as we move through all of these timelines, and we'll be able to move out to give our members information. And let's just look a little bit more about what are the, maybe the implications for executive search firms. Maybe we should look at that. Does that work for you? So how does the AI Act classify and regulate common executive search activities such as automated CV screenings, candidate profiling, video or interview analysis from notes? Are they likely to be considered high risk under the law?
Yeah, so the spoiler alert there is yes, probably they're going to be high risk, but just taking a step back, we've got this slide here, which is really setting out the different, the four sort of regulatory tiers that the AI Act sort of establishes. So as Richard mentioned, we've got a risk-based approach to regulating AI. A lot of it's focused on particular use cases rather than just regulating AI technology per se. So the first risk bucket, which I've already mentioned, is this kind of tier of unacceptable risk, and those are the prohibited AI systems. Again, they're just deemed to be use cases which are deemed to be just so abhorrent or unacceptable based on their impact to individuals that they are going to be outright banned in Europe. So this is going to include those systems that manipulate people's behavior, exploit personal vulnerabilities based on things like age or disability, or social scoring that's used to that could be used to justify unfair or harmful treatment. There is also going to be a prohibition on the use of emotion recognition technologies in workplace settings. We'll talk a little bit more about that in a second. And then we've got this scenario, the second bucket, which is where, as I mentioned, the focus of the law is, where most of the obligations will sit. And that is those systems that are deemed high-risk AI systems, and they're going to be subject to the most stringent obligations under the Act. From an executive search perspective, this is going to include a number of tools that are going to be used to inform employment-related decisions. So think of targeting job ads, analysing or filtering applications, assessing candidates in any way, or systems that are used to support decisions related to promotions or terminations. They are going to fall within that high-risk bucket. Again, we're going to break that down a little bit more in a second. And then we've got this sort of limited risk category. That's not terminology used by the AI Act, but it's effectively what we're looking at here. So these are AI systems that are not considered high risk, but they still require transparency. So this is going to include sort of interactive AI, things like chatbots or generative AI, and applications that claim to detect emotions or classify individuals using biometric data. In these cases, individuals have got to really be, it's got to be clear to individuals that they are being interacting with an AI tool and that they are being evaluated by AI. And then there are certain systems that will fall entirely outside the scope of the regulation, and they're going to only be subject to likely voluntary codes of conduct and basic AI literacy requirements. Again, we'll talk more about that in a second, but probably in an executive search scenario, that's going to include things like your grammar checking tools, your calendar scheduling assistance, basic keyword search functionality that you might use using AI. They're probably going to be sort of deemed more minimal risk. So I think it's worth just digging a little bit more into some of these scenarios. So as I mentioned, we've got this bucket of AI systems which are going to be outright banned. They're going to be prohibited. And I think sort of most relevant to this audience is probably going to be a consideration for whether or not you're using any AI systems that could be deemed manipulative or deceptive. So these are going to be systems that may use subliminal deceptive techniques to basically impair an individual's decision making or exploit their vulnerabilities. Again, if that might be a vulnerability related to their age or socioeconomic status or disability. The other one I think that would require some thought is this prohibition on social scoring. So this is really trying to capture that scenario, I think quite famously, where the Chinese government were using lots of information about their citizens to then sort of score them, and that score potentially having a detrimental impact on their access to services and things like that. So this is really trying to prohibit systems that classify individuals based on their social behavior or personal characteristics. That might be their sexual orientation, their gender, their profession, their employment, or even their performance at work. If you're doing profiling, using that type of information to generate some kind of score that could lead to detrimental or unfavourable treatment, that is going to be prohibited. And we've also got this other one, which is these emotion recognition systems. So are you using any kind of biometric data? So that could be voice analysis, for example, to infer someone's or deduce someone's emotions in the workplace. Are they happy? Are they sad? That kind of scenario is also going to be outright prohibited. So if we think about that practically, so that could include a system that may predict a candidate's reliability or integrity by generating a social score based on sort of unrelated personal data. So that might be their social media activity or lifestyle habits. If we're using that type of information to inform that scoring, and that score is then being used to influence hiring decisions in a way that's seen as unfair or discriminatory, that could fall within the prohibited bucket. It wouldn't necessarily capture kind of lawful evaluation of people, in specific employment situations if that complies with local law requirements. But any kind of more egregious social scoring, we've got to be really careful about. We also need to be really careful about then using emotion recognition systems. So as I say, that's really like doing some kind of facial scan or voice analysis, because we always have to be using biometric data to then interpret or infer somebody's emotions. If we're starting to do that, for example, through some kind of video analysis tool, which may be scanning candidate video interviews to assess things like their approachability, their openness, their sincerity, based on a facial scan or based on a sort of review of the tone of their voice when responding to interview questions, for example, then that is probably going to be prohibited under the Act. So we've got to be a bit careful about some of that sort of sentiment analysis that we might be doing using biometric data moving forward. And then we've got this high risk bucket. And the reason why executive search tools are going to kind of potentially fall within this bucket is that a tool will be considered high risk if it's used for recruiting, evaluating, or selecting candidates, or if it's being used to provide the basis for workplace-related decisions. So whether to promote or terminate someone's employment, or for monitoring and evaluating their performance and behaviour, or even for allocating tasks based on their personality traits or characteristics. And guidance that we have that's already been published on the sort of scope of these prohibited AI systems is very clear that when we talk about workplace, it extends beyond that just employee-employer relationship. It's much broader than that. So it really captures those recruitment scenarios as well. So if you're using any of these tools to make decisions about candidates, it's going to fall within the high-risk AI system bucket. So, and really, why do we care about this? Well, that's going to trigger a whole load of obligations under the Act. The scope of those obligations is going to depend on whether or not you're acting as a provider of the system. So did you develop the system? Whether you're just a user of the system that's being used to evaluate and make decisions about candidates. The bulk of the obligations will fall on providers, but there is an important set of obligations that if you're just a user of the system that you'll need to be mindful of. And these obligations are going to include things like, I don't know if it's worth moving the slide on a couple of slides to talk about, there we go. So it's going to include a requirement to make sure that you're using that AI system in line with the provider, so the vendor's instructions that came with the system. You're going to need to ensure some level of human oversight, so ensuring trained and competent staff are overseeing the system's operation. And then if you as a deployer exercise control over the inputs, the data inputs to that system, you've got to ensure that that data is relevant and sufficiently representative for the system's intended purpose. And then there's also really important transparency obligations. You need to inform individuals and candidates when AI is going to be used in decision making. And then there's also the right to explanation. So individuals are going to have the right to clear explanations around the AI-driven decisions. There's monitoring and reporting obligations, and also the requirement to keep certain logs as well, system-generated logs. So there'll be quite a bit to do there. There'll be more to do if you're a provider, but there'll certainly be an important lump of important list of things that you'll need to do as a user of those systems too. And we are definitely going to be helping you understand those obligations with some of the materials that we're going to be providing through our collaboration.
Thank you, because when you're mentioning all of this, I'm sure that the audience is going, oh no, where do we start? How do we do this? But I know we're going to get great guidance from you and from Richard as well as we go through this. Is there, maybe you could talk about the obligations that maybe executive search firms face when using general purpose AI like chatbots or generative AI, because that's what most people are sort of using at the moment. And how does it maybe treat that differently? You may have already touched on this, but you know, I think you have actually given us a lot into it. But there's also the penalties that are there for non-compliance as well. So maybe you can share a bit about the penalties as well for it.
Yeah, so just a quick note on sort of general purpose AI tools, so those chatbots or generative AI. Some of those AI systems won't automatically be considered high risk. What's going to be really important is if you are, for example, integrating one of those large language models, so GPT-4 from OpenAI or Gemini or any of those sorts, if you're integrating it into your own solution to use, then you can become a provider of the resulting system, having integrated that model. And then you would need to think about your obligations as potentially a provider of an AI system. And those obligations are going to depend on the use case then. So if if you're using that system for a high risk use case, then you're going to default down to the high risk scenario. But if it's just a straightforward chatbot that isn't doing anything, for example, you're just using the chatbot and you're not using it for any particularly high risk scenario, then mostly you're just going to be subject to those limited transparency obligations. So making sure that people understand that they're interacting with a chatbot, that output that comes from that has been artificially generated, etc. So it's quite it's all going to depend on how you're integrating and using those general purpose AI models to sort of understand the scope of your obligations there, and then the use case to which the system is being put. And then in terms of the penalties, Richard, I don't know if you want to dig into that one. People are probably sick of my voice right now.
Yeah, absolutely. I mean, the penalties, it's important to talk about because there are consequences for non-compliance, obviously. So the regime under the AI Act really focuses on the national regulators in each of the EU member states. So they're going to be designated and responsible for enforcing the AI Act. And as Vic mentioned, a lot of the provisions of the AI Act have already come into effect and are already enforced, but some are yet to come into effect. So some of the enforcement is on the horizon and yet to come. But effectively, national regulators will be responsible for overseeing compliance within their jurisdiction, within the country. And a lot of this activity will also be coordinated and assisted from the newly established European AI Office. And this AI Office is effectively part of the European Commission. They're going to be publishing codes of practice, guidance, and also help to coordinate some of the interpretation and thinking around the regulation. In terms of the actual level of fines that can be levied by regulators, so it depends on the actual infringement. But for example, if you cross the line and start using AI for prohibited practices, which Flick mentioned earlier, that carries the heaviest level of penalty, up to 35 million euros, or 7% of your global annual turnover, whichever is higher. That's the potential level of fines for violating the prohibited practices. Other violations, if you fail to comply with the obligations when using high-risk technologies and also failing to deliver transparency, well, those types of violations, there's a lower tier, but they're still significant. So up to 15 million euros or 4% of your global annual turnover. Again, whichever of those two figures is higher. And if you're familiar with the GDPR, you'll note that these fines are significant. They are higher than the GDPR level fines. So it's important to bear that in mind. And when we're discussing this, the AI Act is a comprehensive legislation, but it is risk-based and it's targeting specific uses and types of systems. So we expect a lot of the enforcement, again, is going to be focused on those high-risk areas, and workforce management and executive search recruitment may potentially fall within those higher risk areas and therefore higher consequences as well. Also, Claire, I think it's worth pointing out that there are obligations for users of these technologies. So even if you're merely using a third-party AI tool, you didn't build the tool, you didn't develop it yourself, you're not offering it to others, you're just using it internally, then you do have obligations under the Act. You're considered a deployer, and therefore, as Flick was discussing, you have a number of responsibilities. So you can't necessarily assume that your vendor is going to be liable and responsible. You have also direct responsibilities and could be held directly liable under the AI Act as well.
Okay, that's great. I know you do have a slide there that is showing us actually all those fines. So we will actually share that internally so everyone can understand that. And it is a lot more than what it is. They're a lot more than what it was for GDPR. So that is enough for us all to really make sure that we are working within compliance for that. And maybe, Richard, if we just, move on a little bit about, actually the compliance and risks that we've been talking about. So what does a realistic compliance roadmap look like for a typical executive search firm?
Yeah, and we are going to be working to develop materials that will help support firms in developing a compliance plan. I think really it depends on the firm itself, your size, your level of maturity, the resources you have available. There's not necessarily one size fits all approach. Therefore, there are different approaches to compliance with the AI Act. But at a really high level, we can think about some important steps to take, and these are mapped out on this slide. So when we're working with clients on AI Act compliance and also general governance, the first step we focus on a lot is mapping and ensuring you understand what AI tools you're actually using today and what you're thinking about using in the future. And these could be AI tools that are standalone, or they could be embedded within your existing software applications. Really, this is just mapping out what AI you're using, understanding what they do, how they influence decisions, and where they sit within your workflow. This is a really important first step, because without this, and without a strong grasp of what AI you're actually using, you're not necessarily going to know where your exposure and where your obligations sit. So the second step is, once you have identified what AI is out there today and what you're using, you also need to assess, well, how is it regulated under the AI Act and which risk classification does it fall within? Some of those tools might be minimal or limited risk, but as discussed, some of them might actually fall within the higher risk bracket. And in some cases, you might also need to consider the prohibitions as well. So once you've developed that internal inventory, then you can start to conduct some assessment to understand how you're regulated. At the same time, another important step for firms will be engaging with your vendors. So ensuring you're conducting due diligence as part of your procurement exercise to understand how vendors are ensuring compliance with the AI Act. You've got to be asking the right questions, and also making sure that your vendors are aware of the AI Act. So if you're procuring these tools, you can demonstrate how the tools meet the standards under the AI Act. Another step 4, this is really key. It depends on the size of your firm, but training your staff on the requirements of the AI Act. So Flick mentioned AI literacy earlier. So AI literacy is this concept whereby effectively people understand both the powers and limitations of AI, but also some of the risks and the requirements that are triggered and apply to the use of AI. AI literacy applies across the board. This is an obligation for all types of AI tools, and it's really a baseline. So that feeds into your training, ensuring that staff are AI literate, that they're familiar with your firm's policies, and that they understand what appropriate and responsible use looks like. Finally, and this is probably something that ties everything together, consider establishing an internal governance program around AI. So that's things like establishing an AI mission statement, internal policies, audit processes, etc. Really the framework that reflects your firm's values and regulatory responsibilities when it comes to the use of AI. That's really going to be key to help guide your responsible AI use, but also deliver compliance around regulations like the AI Act. It's also worth flagging that we think it's important to start preparing for the AI Act now. Again, some of the requirements are already in effect, those prohibitions, but even though there's a little bit more time for the core obligations, it'll take time to become familiar with those and start preparing. So now is a good time to start thinking about compliance.
The other thing I just thought useful to also kind of just make sure it's top of mind is that for most scenarios where you're just using an AI tool that you've got from a vendor, so if you're licensing or accessing an AI powered tool and applying it to your day-to-day operations, whether that's sourcing, assessment, or communications, whatever you might be doing with that tool, then typically that would just mean that you are a deployer under the Act. You're just a user of the tool. But we know that as Richard said, that doesn't mean you're off the hook under the Act, because if you're using a high-risk AI system, then all of the obligations that we sort of outlined very briefly are going to apply to you. But really important is that you can also flip into becoming a provider of a system if you start to rebrand a high-risk AI system, or you make substantial modifications to that system, or you change its intended purpose. So again, that's why it's really important to start to implement some kind of governance around how you're using these tools, because ideally, if you're using it, you want to stay as a deployer, and you don't want to flip into becoming a provider if you can avoid it. Obviously, if you're designing your own proprietary AI systems and incorporating AI models to make a system, then you will be a provider. But if you're just consuming a third-party tool, then the goal is to stay in the deployer user lane and just ensure compliance with those obligations.
Thank you so much for that. I think it's really interesting, and there's a lot of I know that those of you that are listening are probably saying there's a lot of terminology coming out here that we're using, whether it's a deployer or provider, but we will be having a guide to the terminology that is being used within the AI Act, and that as well with many other documents will be posted on the AESC members only web page. So do keep an eye on that, as we will be posting over the next few months all of these documents, and we will be communicating out with you on that. If I was to say, Richard, we've got members who are large firms, global firms, small boutiques that are just focusing within 1 or 2 countries, and probably all of this now that you're giving is a little bit daunting. But what would you say if I was to go back now? What should I do now at this point?
Yeah, absolutely. I mean, as mentioned, one of the most important early steps is mapping your AI. I think that's relevant for large firms, but also for much smaller firms as well. You really can't begin to assess your exposure or your obligations until you know what AI tools you're using, how they function, what decisions they're influencing. And sometimes that's easier said than done. You know, AI is becoming increasingly embedded in existing applications, software, and platforms, including ones we're already using today. And sometimes it's also not obvious when AI may be operating or what it's doing under the hood. And that's why a foundational knowledge in AI is so important. You need a basic understanding of what AI is, recognizing it, how it works, and spotting AI functionality in your tools and workflows. That's really a foundational step to understand and evaluate risks and compliance. So the key now is to start building that internal awareness around AI and recognize that this isn't going to be a one and done exercise. This is really an ongoing exercise, and what you'll start to develop is a living, working map of your AI within your operations, and it's going to evolve as you develop too, and as you start using new technologies. It's not just the law that's changing; it's also the tools that are available on the market. So staying abreast of that and recognizing the risks and capabilities is going to be key.
And
Yeah, and
I
I think
know that, sorry, go on,
Oh,
please.
sorry, I was going to say, and another really, I think a really big focus of the law is to try and avoid a scenario where there's discrimination against candidates through the use of AI tools. So I think a big area of focus for executive search firms using tools for candidate screening and scoring and assessment is going to be understanding how the outputs have been reached. So can you explain how the algorithm achieved its particular output? Because we're going to have to be able to explain that to candidates in a meaningful way. So how has the algorithm arrived at its decision? And are we sure that that decision has been arrived at using data that has, and models that have been trained so that they are not biased and discriminatory in any way? Because I think a big area of litigation that's going to grow, that come off the back of this, is candidates bringing unfair claims of discrimination based on the use of AI technology. So I think a lot of this has got to be about thinking about, can we explain how we are using the tools, how they work, how it's impacted decisions that have been reached? I think that's going to be a critical area here.
And that certainly is, because as we move along with the EU AI Act, everybody is going to become more educated, and part of that is as well that the candidates are going to become more educated. So they will be asking these questions, and we need to, as you said, be prepared to respond to them. And I know that we are going to look at, for example, looking at checklists for vendors, and we're going to explore lots more of things like that we'll be sharing with our members. What about, is there any sort of upcoming codes of practice, industry standards, or certification schemes for firms to follow and to demonstrate compliance with the AI Act?
Yeah, I'm not aware of any formal sort of certification schemes that are specifically targeted at executive search. But as I mentioned, we're waiting on a huge body of guidance to be published by the Commission and other bodies to help us all understand how to apply the law in practice. So we've got the Act, it tells us what we have to do, but sort of understanding how we do that and understanding how to interpret some of those provisions, we're still waiting on guidance. So we have some guidance around how to interpret the prohibited AI system provisions. We're waiting on the guidance for how to really interpret the high-risk AI systems. I think once that comes out, it's going to be really important to dig into that, to understand, how we apply that to the workplace scenario properly. The Commission is also working on certain codes of conduct which are going to apply to providers of general purpose AI models. I think those aren't going to be so relevant to many people on this in this audience. It's really focused on the open AIs, the Googles of this world that are developing those large language models and other general purpose AI models. So they're going to have certain voluntary codes that they can sign up to demonstrate how they're complying with the requirements of the Act that apply to them. But unfortunately, there's no official sort of certification scheme yet that executive search could sign up to be one and done and compliant with the Act.
It is worth mentioning there are a proliferation of new general standards and risk management frameworks that members might be familiar with or have heard of, like the NIST AI risk management framework, and there are also some ISO standards. There's a lot coming out and there's a lot of work in this space. But as Flick says, none of those frameworks have been designed specifically with the AI Act in mind. So they don't necessarily guarantee compliance with the law. But frameworks like that do help to establish these internal governance frameworks that I mentioned earlier, which will help to deliver some aspects of compliance.
Yeah, there's also a draft report actually that came out, I think it's this week, which is sort of urging the European Commission to propose a separate directive on AI in the workplace to set out clear rules on transparency and human oversight for algorithmic management systems. That is incredibly early days, but you can see there's some background lobbying as well going on to think about how we may even in the future introduce some separate rules that are very specific to the use of AI in the workplace. Very early days, but I'm just raising it. There's a lot of legislative initiatives going on in the background.
Okay, no, thank you for that. And I know there's some questions coming in wondering if Fieldfisher is actually interacting with the EU Parliament or the Commission or anything about that when they're developing these codes. How close are you to that?
Yeah, so we have a Brussels team. So we have a fully staffed up Brussels team who are very much at the heart of sort of some of our lobbying initiatives on behalf of our clients. So they're very well placed out there to kind of help with those pieces. We have on behalf of our clients, for example, the General Purpose Code of Conduct was out for consultation. Some clients wanted to submit feedback on that, and they will often engage us to sort of help with those types of activities. So we do get involved in that. I think some of the sort of more hardcore lobbying that goes on would go through our Brussels team, who are sort of better placed out there to do it. But Fieldfisher as a firm definitely involved in that, and where a client wants to help, in submitting feedback on open pieces of guidance or code that are relevant to what they are doing, then they may engage us to kind of help with that sort of feedback submission.
Okay, no, thank you very much for that. And we've got one specific question in here, and that's is it considered high risk according to the EU Act if I use instant chat GPT to summarize a profile taken from LinkedIn? So they're taking profiles from LinkedIn, putting into chat GPT and then asking it to summarize that profile. Is that a high risk?
No, I don't think that's necessarily high risk, because it's not being used at that point to make a sort of workplace decision. You're just using it to generate an insight about an existing profile. So I think you're fine. That's not high risk.
It's a great question and reminder that there are going to be some grey areas and some careful thinking about where you're using a tool for a pretty straightforward task like summarization or drafting or something straightforward like that. And then when it tips the balance and scales, and then it moves more into the evaluation aspect and where you're actually using that tool to actively evaluate candidates. For example, it's not just summarizing someone's LinkedIn profile, you're actually interrogating the tool, asking questions for the tool's feedback on the candidate. Can you rank this candidate? Can you evaluate them against these kind of metrics, etc.? So something like summarizing, probably not, but if it's doing something a bit more, if it's doing a little bit more critical analysis or thinking on your part, then that might step towards a high risk use case.
Okay, thank you. And I know we're going to explore more of these sort of grey areas and how do we actually navigate and how do we go through that over the next 18 months. We do have more questions coming in, but I do know that we're nearly at the top of the hour, and there's a lot that we're going to do. I know that you've put together a great, I would say, toolkit that we're going to be using as we go through with our members. The first couple of things will be coming out within the next few weeks, which we'll have post on our members only website. I do encourage you, our members, if you have any questions, if you have any contact that you need, I think we do have a slide there with some contact details as well for Fieldfisher. But maybe first of all, before we go to that, actually just run through sort of the final thought slide that you have there, and that will really give everybody a sort of a summary.
Yeah, I mean, one key takeaway is the AI Act is going to be a game changer for executive search and leadership consultancy because of its heavy focus around the use of AI in workplace decisions. So definitely something to be aware of, something to start thinking about and taking steps towards compliance. And that process really should begin now. The high-risk obligations don't start until August next year, but they're pretty extensive and they need thought around them. So we suggest really starting to think about it and building that compliance, starting those compliance efforts now. Flick, do you want to continue with any of the others?
Yeah, so and I think there's one big point here, which is that even if we think some of what you're doing isn't regulated as high risk, there's a really important reason to put in place a sort of some kind of hygiene AI governance program so that you can start to understand and build and integrate AI in a way that's going to ensure compliance with not just the AI Act, but broader privacy regulations, which is always going to apply whenever you're using these tools to process personal data, or if you're using it for automated decision making. So having some way of catching as an organization what AI you're using, having a kind of set of principles that you think we as an organization, when we're using AI, we're going to try and sort of comply with these core principles, I think becomes really important. Managing your vendor compliance. So when you're acquiring a new tool that you're going to be using, do you really understand how AI is being used there? Some of the vulnerabilities that might or limitations of those AI tools? Have we got the right disclaimers around how we're using it? None of that can really be addressed without having a proper sort of governance program in place that looks at and has processes in place to catch use cases, properly review them and categorize them. We understand all of this could be immensely challenging for organisations which don't have, a full in-house legal team or even an in-house compliance team. But there are some hygiene things, some quick wins that can be sort of implemented to make sure that we're starting to address key risks that could arise from using and integrating AI. And again, those are some of the things that we're going to sort of push out to you as a set of members through the collateral that we're working on to give you those, what are the basic things we need to be thinking about here.
Okay, well, thank you. We're here at AESC, we're very excited to be collaborating with you. And I would like to thank both of you for being with us today and sharing your insights. And maybe some of us will go away thinking, oh God, there's too many insights for us. But I know we will be having more webinars throughout the next few months to talk about this. We will be providing updates to our members over the next few months. And I encourage all of our members here to visit the AESC members only website, where go to the legislation page and there will be posting updates as we move through this journey together. If you do have any questions in relation to the EU AI Act, you can please contact myself, or you can contact directly Fieldfisher at info@fieldfisher.com. But we will be coming together and getting you more collateral about how you can navigate through this, through the EU AI Act. So thank you, Felicity, and thank you, Richard, for joining us. And thank you all for participating today. I hope that you found it interesting and has given you some insights and food for thought. So thank you.